Good morning. Thank you very much for joining us for our biannual employment law update. For those of you who attended our employment law updates last year, you will recall perhaps that we got part of the way through our March employment law updates only to be hit with lockdown and then had to cancel the rest of them and do them by webinar. Obviously, when we came to do our autumn employment law updates, we were in the same position, and that has unfortunately carried on to our spring 2021 employment law updates. But we very much hope that by autumn, when we come to do our next set, we'll be able to do those face-to-face, but of course still with a webinar option. I'll just talk you through what we're going to cover in a moment. Before I do that, just a couple of housekeeping points. You are able to ask questions throughout the session today. You can do that by clicking on the questions section of your panel and submitting your question there. You'll be asked to participate in a few different polls throughout the session today, and likewise you'll find the polls section within the panel. At the appropriate point, you should see that come up on your screen. There are also two handouts for today's session. One is a copy of the slides, the other is our usual brochure which contains case summaries of all the cases we're going to discuss today. So there's no need for you to go through and take extensive notes as we go through the session. My name's Lorna Gemmell. I'm the Employment Law and HR Training Manager for Law at Work, and my colleague who will be co-presenting with me today is Ben Brown, one of our employment solicitors. So I'll talk you through the agenda for the session today. I'll then pass over to Ben, who will do the first part, and then Ben will pass back to me to complete the last part. And hopefully we'll be able to answer your questions as we go through, but there will be hopefully an additional time allocated at the end for questions which come into your mind at that point. So hopefully you can see my slides on the screen just now. So let me just talk you through what we are going to discuss today. So we'll start off with a key case update. Ben's going to do that section, and he will talk about some unfair dismissal cases, some discrimination cases, and some employment status cases, including, of course, the very recent and high-profile Uber decision. I'll then talk you through some legislative and other developments. There hasn't been a huge amount of legislative developments for obvious reasons over the course of the last 6 months or so. It will be interesting to see how the government proceeds with some of the plans that were in place towards the end of 2019, when perhaps the pressure associated with coronavirus is relieved. We'll then move on to think about some coronavirus related themes. So we'll think about vaccination, whether that's something employers can introduce within the work, not introduce, but can require of their employees. We'll think about testing in the workplace, and we'll think about some considerations going forward post-lockdown, things like hybrid working and the potential advantages and factors to consider in that respect. We'll spend a little bit of time thinking about Brexit, something which a couple of years ago, of course, was at the forefront of everybody's mind, but seems to have moved slightly back, obviously with other priorities in the course of the last year. So we'll talk about potentially some of the changes that we might expect to see to our employment laws now that we're no longer bound by the decisions of the European Court of Justice or the directives issued by the EU. And I'll give you a brief run through of the new points-based immigration system, which came into effect in January. And then, as I say, we'll hopefully finish off with any final questions. I should have said, if you do encounter any technical problems throughout the session today, please pop your question into the questions section. We have our IT expert here for the first part of the session, so hopefully he will be able to help you with any individual issues that you have, so that you can participate in the remainder of the session. Great. Okay, well, I'm going to pass over to Ben now, who will take you through our key case update.
Perfect. Thank you, Lorna, and lovely to be here presenting today from Glasgow. Obviously, I can't see exactly who's on the call, but I'm sure there'll be some people there that I know pretty well. So lovely to speak to whoever's with us today. As Lorna says, I'll be running you through some kind of key case updates that have come through in the past kind of 6-month period, and some interesting cases from the Supreme Court more recently as well. I'm not in control of the slides, so I'll have to do my best Chris Whitty impression for Lorna to tell her when I need the next one, but we'll try our best. So Lorna, without further ado, next slide please. Perfect, thank you. And I also realised that I always forget the attendees always get a case summary as well. So by all means, feel free to fact check me or comment on any bits as we go through here in the questions section, as Lorna says. But the first couple of cases are two quite interesting cases regarding unfair dismissal. The first one on the list here, K versus L, may well be aware to some people, an anonymised case, and possibly for good reason, that it's a bit of a grim factual background. It was a case involving, it was in a school setting, and one of the teachers, there was allegations that they were downloading indecent images of onto their school laptop or their school computer. And this was raised to the police. The police went in and raided and confiscated the laptop, I think it was, and looked into it. And essentially, the procurator fiscal came to the conclusion that there wasn't really any particular evidence of wrongdoing here, so no criminal charges were brought. And it's probably also worth pointing out that this was a teacher, very long-standing, over 20 years service, no past disciplinary record from an employment perspective, and otherwise up until this point had been quite a well-regarded member of the faculty and member of the school, but obviously pretty serious allegations that were levelled against them. So the school, he was suspended whilst the criminal investigation was going on, and then obviously when that was dropped, the school, perhaps understandably, were still a little wary of bringing this teacher back into the school, so decided to do their own investigation. Went to the fiscal and asked for all of the materials that they collated, and got that back. That it was heavily redacted though, so it wasn't hugely beneficial to the school when they got it. But nonetheless, they decided to start a disciplinary process on the grounds of misconduct. And as they ran that through, they came to the conclusion, ultimately on I suppose a few different points, that one, that they couldn't be sure that there wasn't misconduct from what they looked at, the stuff that the Crown had collated, that there was no clear evidence that he did do it, but neither was there any clear evidence that he didn't do it. And they decided that that was too much of a risk, and also on the grounds of reputational damage. They said that there was a potential reputational damage here, so they couldn't let this person continue to be in their school. And the teacher wasn't, so you got dismissed, apologies, so summary dismissal. The teacher challenged this and brought a tribunal claim on two fronts, really. The two main points of this case was that, so part of the reason was a kind of SOSR, reputational damage type idea, which wasn't really told to him at the start of the process. It was in the decision right at the end, but there was no lead up to that. There was no awareness or notification that that was going to be one of the grounds for him to respond to. And the second point, obviously, that there was no real evidence there that he committed misconduct. They just said, well, there's no real evidence that he didn't. And at the first instance, the Employment Tribunal agreed that that was a fair dismissal, but it went to the Employment Appeals Tribunal more recently, and they overturned the decision. They said they thought it was an unfair dismissal, basically on those 2 points. You can't just go on the fact that there may be a suspicion that there was misconduct, that in of itself isn't enough. And likewise, I think an important point to remember is that if you are going to dismiss or otherwise give a sanction for an allegation at the end of the process, you need to be notified at the start of the process so that this employee can respond and interact with that and give representations on that. So the fact that there was no reputational damage at the start the EAT were quite critical of that when it got to the end, that was one of their main points that they decided to dismiss him on. So they ruled that it was unfair. I mean, I think in practice, there'd be a strong kind of poll-cake argument that could be made, and any compensation for that being unfair could probably be reduced accordingly. But I think, and two important takeaway points from that case, that you need to have more than just an inkling or a feeling or a suspicion of wrongdoing, and also make sure that your process is consistent from start to finish in terms of allegation to sanction at the end, that we're reflecting a mirror image of one and the other, so that the employee can respond in that middle piece. The second case on that list is quite an interesting case, one of the first of its kind, to do with coronavirus mask wearing and that kind of element of it. As a slight point of interest, I did know that one of our ex-colleagues, Andrew Maxwell, for anyone who knows who that is, was involved in this case. And essentially, in a nutshell, the employee in this case was a delivery driver and was going in and out of a client site. So he worked for Kent Foods, and one of their clients was Tate and Lyle, the sugar manufacturer. So they went in, he delivered into Tate and Lyle, and when he arrived, they asked him to put on a mask, and not just a mask when he's out and about in his site. However, though, it was to wear a mask whilst he was in his cab or in his van, and he refused. He kind of pushed back on that and said, well, I'll wear it when I'm out and about, but when I'm in my cab, that's my personal space. So I'm not going to wear a mask. There's no regulations or guidance to suggest that should be the case. So the issue, I suppose, was, though, that Tate and Lyle weren't particularly pleased about that he was refusing to follow their health and safety guidelines, fed this back to Kent Foods, and Kent Foods were quite critical of their employee, because in their handbook there was an obligation that they must follow all of the health and safety procedures of any clients that premises that they go into. So they said, well, fair enough that there was no government guidance, but that's not the point. It's, you were very clearly told, you know about it, the fact that you need to follow what our clients tell you. And in terms of health and safety procedures, we think that was a reasonable thing to ask. And the fact that you didn't follow that has caused us issues in terms of kind of relationship with the client, etc. And they based it on the fact that he's breached this obligation in the handbook as to why they were disciplining him, and actually decided to dismiss him in this case. And I think, interestingly, the tribunal has ruled that that was a fair dismissal in the circumstances. They did say it was a harsh decision, but within the band of reasonable responses of if you're clear of what the expectation was of the employee, that's fine to follow that through. And I suppose worth noting that it's a tribunal decision at this stage, so not necessarily binding on all other tribunals, or it doesn't necessarily set a precedent, but it is the first case of its kind. So it's an interesting case, and would be interesting to see how this kind of line of case law develops as we move forward. I think that takes us on to our next slide, please. So a couple of discrimination cases up next. The first one on that list, Cummings versus British Airways. I feel British Airways seem to get into trouble quite a lot at the moment, and maybe that's unfair of me to say of British Airways. I'm sure they wouldn't be happy with me calling them out on that, but it does seem to be the case. So both of the two cases on the screen just now are indirect discrimination cases. So I suppose it's just a useful reminder, both in terms of I suppose what indirect discrimination is, where the pitfalls are, and potentially the justifications for defending the claim. So looking at the top one, the British Airways case, that was where British Airways had a policy, and I suppose maybe worth just saying before I launch into it, that indirect discrimination, as I'm sure many of you will know, is where there's a PCP, so that's a provision, criterion, or practice, normally a policy of a company, that has, and to be indirectly discriminate, it has to have a kind of disproportionate or disparate impact on a particular group that has a protected characteristic. So normally, most commonly, I think you find that with a disability or perhaps sex, as is the case for this for the British Airways case, which their PCP or their policy was that if a member of cabin crew had 3 or more days of parental leave in 1 month, that if they had 3, that would mean that they deducted 1 day of annual leave from their annual leave entitlement for that year. So this was challenged on the basis of it being indirectly discriminatory on the grounds of sex, because the argument was that women tend to, or generally will still have, the expectation of child care responsibilities. And I actually think an interesting point Lorna and I were discussing before we came on, there was an article that was published recently about parents working during lockdown in coronavirus times, and apparently that when they looked at the figures, that if a mother was working, that in average they could get about 1 hour of uninterrupted work time, where if it was a father that was working, it was more like 3 hours of uninterrupted work time. So perhaps it still does show, or is borne out, that females or women will tend to have more of the child caring responsibility. And I thought that was an interesting study or an interesting article, at least. But back to the case essentially said that this is indirectly discriminatory towards women, and the tribunal in the first instance said, well, no, we don't think it is, because it applies directly to males as it does to females, and this is just applied across the board. But I think what's interesting is then this got appealed to the EAT, and the EAT were pretty critical of the ET's thinking in the first instance, in terms of saying, well, you've not really applied the correct pooling there, or the correct comparison, because you can't just say, oh, well, it applies equally and jobs are good. And that's kind of, I suppose, more of a direct discrimination type argument. When you're looking at indirect discrimination, you need to be quite specific as to the pools who it should apply to and what the effect is. So what the EAT said was that the correct pool should be males and females or cabin crew with childcare responsibilities, and in that case, as perhaps those cases show, and the tribunal seems willing to accept, that it still appears to be the case that females bear more of the childcare responsibility. So it's an interesting point to remember that policies and or PCPs can be indirectly discriminate on that, and we need to be mindful of that, I suppose, especially when implementing a new policy or policy change. The second case on the list is quite a niche point, and I'll try and explain the best I can, and I won't spend too much time on it, because it is quite a niche argument, and this is looking at the justifications for an indirect discrimination case, this time on the basis of age. The facts of this case, very briefly, were that we're looking at public sector, so the employee was a probation officer, and the Secretary of State decided to bring in a new policy about pay increments, about how you would build up on pay increments on your scale. And what it used to be is that you build up on increments, and it would take about 7 or 8 years, roughly, to get from the bottom when you came in new to the top of your pay scale. They decided to change that because of costs and limitations in their budget, that it would then, if you were new coming in, it would take about 23 years to reach the top. And this was challenged on indirect discrimination grounds, saying that, well, if you're at the top, you're more likely to be older. It's more likely that new employees coming in will be younger, and this has a disproportionate impact to younger employees, younger probation workers, or probation officers, sorry. And this was ran to, I think it went all the way to the Court of Appeal. Oh no, it's the EAT, apologies, that it made it to here. Oh no, it did make it to the Court of Appeal, apologies. I was right the first time. And it was looking at this justification point. So can indirect discrimination, like I said, is one of these ones that you can justify to say we've got a proportionate means of achieving a legitimate aim here. And when looking at trying to justify this, there's a few principles that are set out. One being that you can never justify it on costs alone. So you can't have a potentially discriminatory policy purely because of costs. And that's always difficult, because I think a lot of policy changes for businesses will be born about because of the financial situation or the commercial situation behind the scenes. But the tribunal says if it's potentially discriminatory, it can't be costs alone. What it can be is kind of costs plus. So if there's costs in the mix and there's other legitimate concerns as part of that, then that may well be a proportionate means of achieving a legitimate aim. In this case, and I would say this is public sector, so be mindful of that. I think the tribunal would be more willing to come to this conclusion in the public sector as it may have done if this was a private sector case. But they said that Secretary of State, effectively, they made the decision because of cost. They had a limit on their budget, but they've made a distinction that that's a bit different to a costs alone type argument. This is a kind of absence of means, because they had their budget set by the government that handed down what their budget was, and there was particular constraints that were put upon them by an external third party, effectively, that they had to mitigate around. And that in of itself was slightly different to just deciding to make a policy change because of costs alone. They said that was a wider consideration, and like I said, quite a niche point, so it's probably not applicable to a lot of the businesses that the attendees are from at the moment. So I won't say any more on that, but if that is of interest, then feel free to ask questions, as Lauren said. And if we can have the next slide, please. Okay, cool. So the top one, the reasonable steps defence. This is quite an interesting case, and I think a really good one for takeaway points for people here. So if you take away any case, I think this is probably one of the more important in terms of discrimination cases. So this is looking at a reasonable steps defence. So in certain circumstances, and again, this kind of leads on from the justifications, a business can say, well, we took all reasonable steps to prevent, in this case it was harassment, from occurring, because we did training and we made staff aware of expected conduct and all that kind of thing, and therefore it's not our fault, or it's not our issue as the employer. We've done our bit, we've held up our end of the bargain. This is the employee's issue. They've went rogue, kind of thing, and probably quite simple terms, that's essentially what we're saying. We've done our bit. This is the employee's issue, not ours as the employer. And in this case, there had been some kind of equal opportunities training, equality diversity training that had happened, but this was in 2015, the training, and then a couple of years later, then there was an incident where there was some discriminatory comments or harassing comments that were made to a member of staff by an individual or a couple of individuals. This was known about to a certain degree in the workplace and by managers, and wasn't dealt with particularly effectively. And a harassment claim was raised off the back of it once this employee had left the organisation. And what the employer tried to say is, well, we've done our bit, we've done our training, and we did all this in 2015, and the people who had done the harassing had got their training, which so we held up our end of the bargain, judge, and the tribunal and EAT, as it got to, were not persuaded by that. And what the quote that's come out of this case is that they thought the training was stale. So the fact that it was a couple of years out of date, they said that's not quite good enough to have this statutory defence to harassment. It needs to be topped up on a regular basis, and I would probably suggest year on year you want to be doing a kind of refresher training to keep this statutory defence alive. You can't just do it once and expect that to last for forevermore. Once people have had one short week of ops training, that's then covered, or that's the business covered. The EAT have said, well, quite clearly not. And also probably just worth pointing out that they were also clear that if we're doing top-up training or refresher training, this can't be kind of superficial or brief. So it couldn't just maybe be like a wee 5-minute, watch this 5-minute video, or wee 5-minute tick box exercise or something like that. It would need to be relatively substantive, and obviously there's no exact guidance on that, but let's just assume perhaps maybe like an hour's worth of refresher training or something in that ballpark. I know we had a discussion internally in the office, and Lorna was a big part of it in terms of when we were designing online courses as to what would be substantive enough to continue to qualify on this kind of reasonable steps defence. So worth being mindful of if you are doing refresher training, that it shouldn't just be a formality or paid lip service to it. It should be something that's relatively substantive to keep this alive. The second case there is Taylor versus Jaguar Land Rover, which is a case on gender identity, which I think is well timely clarification, because it was a slightly unclear picture up to this point. And in this case, the employee in question was gender fluid or non-binary, and there was various comments, and it was relatively egregious comments, to be honest, from other colleagues in the workplace, and I think that's an important factor, I think, to remember from the outset, that this was relatively bad in terms of how this person was treated. I think I don't think it would be unfair to say I think the Jaguar Land Rover workplace was maybe slightly more traditional or old-fashioned in its views, and the staff were particularly accepting of this person who was not identifying as a particular gender, and they had issues with going to the toilet and that kind of thing. So this person wasn't particularly well treated, and raised a discrimination claim on the grounds of their gender identity. And this is where I suppose there's been a bit of, there's not been a great deal of clarity, because when you look at the Equality Act, of course, there's the protected characteristics, one being gender reassignment, which was the relevant one in this case. And when you look at gender reassignment, I suppose there's an argument to say it's maybe not quite fit for purpose, as it was cooked up pre-2010, I suppose, by David Cameron and Nick Clegg at the time. These types of issues and probably weren't nearly as prevalent when the Equality Act was created as they are now, a decade plus later. So this category of gender reassignment that's protected deals with where you're looking, well, first of all, where someone's transitioning from one sex to the other, from male to female or vice versa. So when you have someone that doesn't identify as either male nor female, then how does that fit? Because it's very binary in its language in the Equality Act, and likewise it says that you have to be going through or transitioning through a physiological change from one to the other. So often where there's a non-association with one or the other, that doesn't exist, but there's no physiological element to that. So it was unclear as to how these issues fit in with the black and white wording of the Equality Act, and the tribunal, and I think completely rightly so, in this case said, well, no, that we think this absolutely should be covered. They're quite categorical that these types of issues should be covered by the Equality Act. It doesn't particularly matter whether the precise wording of it supports that or not, but this is in line with the kind of intention of what the Equality Act is supposed to do, and this should be covered and should be covered under the gender reassignment characteristic, and I think, like I said, that's welcome clarification that this is where it fits. I mean, I think there's maybe some debate as to whether that it would go in the kind of philosophical belief type argument, or whether it would go in the gender reassignment protected characteristic, and obviously the tribunal has decided that that will go into the gender reassignment category, and I think a positive result for protections under the Equality Act moving forward, and worth and about time too, probably. Cool. So Lorna, if I could have the next slide, that would be perfect. Okay, cool. So this case, kind of coming up to the end of the discrimination cases, there's been a few, I realise, so you might have come across this one before if you've been at a previous employment law update, and I suppose it's just a point to reinforce, just because it's worked its way a little bit further up the food chain of the courts, so to speak. So this case was got a bit of media attention at the time. It was a non-exec director for the NHS, who in his off time was also a lay magistrate in a magistrates court in England, and he was pretty critical, let's say, of same-sex couples that adopted children and raised children, and understandably so, this got quite a lot of media attention, partly because of his position as a lay magistrate as well, and the work that he'd be doing is that it was commented on quite widely, that he was being so forthright with his views. So where this related to the NHS, they were obviously a massive organisation, and they went to their director and said, look, we understand that you have this belief that in terms of same-sex couples and adoption, etc. We're not saying that you can't have that belief, or we're not punishing you because of it, but you need to understand the effect it's having for us. They were NHS, huge organisation, had many internal bodies set up for LGBTQ plus support groups and everything that surrounds that. And they were saying, well, look, you're causing us real issues internally, because one of our non-exec directors is having these views, and our groups and our staff are not very pleased that our non-exec directors being quite as forthright with this. So can you please stop doing so many media appearances, and or can you just even let us know? Can you be mindful of the effect it's having? Let us know. Let us kind of manage this or be in front of it before you're giving media appearances. And effectively, the non-exec director, he didn't take any notice of this at all. He charged on regardless, gave every media interview that was being offered to him, and the NHS Trust decided not to renew his directorship when it came up for retenure, and he said that he believed that was discrimination against his beliefs, his belief system, or based on religion, etc. So this was obviously disputed, and the point that was kind of the most important point here is that there's a difference, and there's a whole tract of cases along this kind of line, but it's just worth noting that this has kind of been reaffirmed further up the food chain, that there's a definite difference between someone having a view, which may well be protected under the Equality Act, but how they espouse that view and how they put that out into the world and the effect it has is something very different. So because the NHS had approached him quite reasonably and said, look, you need to give us foresight, can you work with us here to try and manage the issues that you're causing us, and he effectively disregarded that and threw that out the window by all intents and purposes, that they were entitled not to renew his tenureship on that basis, because it was his conduct rather than the fact he held this view or belief in the first place that was the issue. So a worthwhile takeaway, that just because someone potentially pushes back or said, I think I'm being discriminated on this basis, we can still act on issues of misconduct or conduct issues that are leading to knock-on consequences, etc. And that's not going to be discrimination, and that's been affirmed. Okay, cool. So we're getting to the end. I've got a couple of Supreme Court cases still to come up, which we'll talk about briefly. But before we get there, we'll do a little bit of audience participation and doing a poll. So obviously one of the more widely reported Supreme Court cases was the Uber case, which obviously looked at, as I'm sure many of you will know, is in the news a lot, the difference between worker status and employee status or self-employed status. So we thought it would be useful to see or gauge the awareness. Hopefully it should be okay after the publicisation, of the Uber case, but see what you know about employment rights that associate with different categories of status. So what I'll do, fingers crossed it works well, is I'll pop a poll up on the screen, and I'll give you about 20 seconds-ish to answer it. You should just be able to click on whatever answer you think is right. I think we've got 10 or 11 and you just click on which one's right, and then I'll show you the results to see how much knowledge you guys have as the audience. So let's have a look. Let me try and launch this. Perfect. So hopefully you guys can all see that. So the right to claim unfair dismissal, is that employee only or both employees and workers? I think we're up about 20% vote, so I'll leave it just another 5 seconds or so. So get your votes in. Feel a bit game show host there like that. Okay, we're over 70% now, so that's good. I'm going to close that poll and see if I can share that for you. Okay, so we're about 60-40 split, which isn't bad. Let me get rid of this on my screen. So 60-40 split, but 60-40 split the wrong way. So the right to unfair dismissal is for employees only. It's not for workers. If you are a worker, then you do not have the full suite of employment rights, and you cannot claim unfair dismissal. So interesting actually that's coming out 60-40 that way. So maybe this will be a more interesting poll than I was thinking. Let's share number 2. So the right to a redundancy payment, employee only or both employees and workers? It seems to be that the first 20 seconds or so no one votes, and then everyone comes in after 30 seconds. I wonder if there's some strategic Googling going on here. Cool, I'm going to close that one as well. Okay, so this one you are absolutely correct, the majority of you. So again, the right to a statutory redundancy payment only applies to employees rather than employees and workers. So good knowledge on that front. Another one. So the right to be paid the national minimum wage. What do you guys think? Employees or employees and workers? Okay, we're good. We're up over 80%. That's a good return rate. So again, absolutely correct. You are improving, improving question on question. National minimum wage is one of the points that applies to all, and one of the boons, I suppose, for the Uber case and then being classed as workers, is that they will now have to be paid the national minimum wage for the work that they do. So absolutely correct on that front. Let me give you another one. Okay, so the right to request flexible working, obviously quite more so a buzzword now, as it ever has been. So what do you think? A bit more of unsurety in this one, it seems. Right, we'll close it there. Okay, so not bad on that split, 3/4 on employees only, and you'd be right, employees only is the correct answer. So the right to request flexibility under kind of flexible working request for employees only. I suppose the rationale being that if you're a worker, then by and large there's no obligation anyway for you to offer and or accept work. So I suppose it'd be a slightly strange one if you applied it to workers as well, but 75% of you in the right there, so well done. Let's try this one. So a minimum period of notice for termination, what does that apply to? So your minimum of a week up and then additional week for every year's completed service after 2. This is a very even split. I enjoy being able to see the results as they come in. So I'll close it off there. So more of an even split, but the correct answer came through in the end. So people who voted employees only, absolutely correct. The right to statutory minimum notice, like I said, for a month plus is a week, and then an additional week for every year's completed services applying to employees only. There's no notice that would necessarily be due if you were falling into a worker status. But I suppose one to be mindful of is one where sometimes if employment relationships morph or change over time, that this is one you can maybe get caught on. They might start as a worker and start to become more solid as the process goes on. So, but it's worth being mindful of. I've got a few more to share with you, and then we'll move on. So the right to maternity leave, what do you think? Employees only or both employees and workers? It's a shame. If I'd been more prepared, I'd have got some dramatic music in the background. Right, that's more of a game show. Cool, so I'm going to close it off there. So an extremely even split there, and one of these ones where the incorrect answer had actually come out on top. So the right to maternity leave is what we're looking at here, and this is, I suppose, a similar rationale to the flexible working piece. Maternity leave, because I guess that the worker status doesn't have any obligation to continue to pick up work. They can stop whenever they wish to. They don't have that right that sits in for the leave portion of maternity, whereas employees would. So interesting that that's come out as such an even split again, but incorrect is the. Oh, sorry, that. So we'll do 2 more perhaps, and then we'll move on. So whistleblowing rights. What do we think? Again, is it employee or is both employee and worker? So whistleblowing obviously being where there's a protected characteristic, sorry, a protected disclosure, apologies, on whatever grounds. Normally at the moment we're seeing health and safety related issues. I'll give it a few more seconds. I'll close it there. So absolutely correct, and big majority in this one. So whistleblowing is one of these types of issues, and I don't don't think any spoilers here. It's one of these ones, whistleblowing and discrimination type issues are one of the, or two of the all-encompassing points for both employees and workers. So any whistleblowing protections equally apply to workers. So we'll do one more. So the right to claim unlawful deduction of wages, is that employee only or both employees and workers? A lot of people quick off the mark on this one. So I'll close it there. There's a lot of you that voted. So again, completely correct. Employees and workers can both raise a claim for unlawful deduction of wages. I'll not do any more of the polls and we'll move on just because I'm conscious of the time, but just very briefly to say that the categories that apply to both, we've discussed most of them, but whistleblowing, issues under the Equality Act, so discrimination type concerns, minimum wage, unlawful deductions, as is there, and I suppose the one that we've not touched on is the working time regulations. So anything under the working time regs would apply equally to both employees and to workers. Cool. So I will hide that and ask Lorna for the next slide and very briefly touch on some of the Supreme Court cases. So I will, we've indirectly touched upon a lot of the issues with Uber there, so I'm sure a lot of you will be well aware of the facts here that essentially they were looking at what status they are, whether they were self-employed, which effectively has none of the protections we talked about, or whether they were workers. And in this case, a Supreme Court case, they decided that they should be workers and therefore get those kind of 5 tranches of protection, which I think in this age of increased use of platforms like that, especially with Deliveroo and Just Eat and all that kind of thing as well. I know I'm bad for using them in the current day and age. I think it's probably not an entirely surprising decision. If you look at the level of control that that Uber was exerting upon these people as to what they had to do in the time they were working, I think it's probably the correct decision and definitely a win for a lot of people who are doing this type of work. Or potentially fallen out of work and are picking this up in the interim and things like that. So definitely a very worthwhile decision, and as we saw, gives them that additional protection. I won't say any more on that just now. Neither will I say anything on that case down below, which is similar points to the franchise agreements, just because I don't want to take up too much time on that. But as Lorna said, if you wish to ask any questions at the end, then please feel free to do so. And I'll, for the final time, ask Lorna for the next slide. Oh, actually, I won't, because it's not on the next slide. I was just going to mention the 2 other Supreme Court cases. The Supreme Court seems to do all of their admin in February and March, so three employment decisions in quick succession. The 2 which aren't on the slides, which I'll just very briefly mention, is the Royal Mencap case, which is to do with sleepover shifts. So mainly care sector. And I'm sure if anyone's in the care sector here that you will be well on top of it, but so care sector where you pay a flat rate for sleeping over a night shift, and there was an argument as to whether that should be working time in terms of the national minimum wage and the working time regs. So the long and short of it is that this has been chopped and changed all the way up to the Supreme Court. The Court of Appeal said no, it shouldn't. And this has had one final line of appeal to see whether this should attract national minimum wage. And in essence, the Supreme Court says no, it shouldn't. When you look at what I suppose the default is, the default in this case was that Mrs. Tomlinson Blake was to was to sleep, and it would only be in the rare occasion where there was an emergency or otherwise that she would expected to go and do work. There was no duty set for her over the night. She was expected to sleep and just deal with issues occasionally as and when they arose. So interesting decision on that one in terms of them saying that no, it shouldn't. And I think a lot of care sector employers will have been breathing a sigh of relief. It's a sector under pressure, and that may well have influenced the Supreme Court's decision, perhaps, in terms of it's well known that that's a sector that's not particularly flush with cash that could perhaps afford to pay national minimum wage for these types of arrangements. So employers, I'm sure, will be pleased. I'm sure for care workers, they will not be so pleased, consequently, because there could have been a reasonable chunk of back pay in there, as well as more pay going forward. So yeah, tricky, interesting decision, because it is, I suppose, we've got a lot of Supreme Court decisions coming in quick succession, coming to slightly different conclusions here. So an interesting case nonetheless on sleepovers. And the final one, just to mention from Friday, just there, was the ASDA equal pay case. I don't know if you saw our very own Donald McKinnon on the STV News talking about it. He's probably more eloquent than I on it, but essentially it was a preliminary point as to whether there's a big equal pay case, probably the biggest in the private sector I can remember, about 38,000, 40,000 claims against ASDA, and not just ASDA, Sainsbury's, Tesco, Morrison, they're all caught up in it, that looks at essentially whether the kind of retail staff and distribution staff should have this kind of collective terms. It's a equal value and equal pay claim, which I suppose is probably the hardest one to bring successfully. And this was just a preliminary point that had made it all the way to the Supreme Court, and effectively saying whether can these retail staff and distribution staff be comparable, should they have collective terms. And I think, unsurprisingly, the Supreme Court said, well, it's a relatively low bar. I think it would have been a shock decision if they said we're not going to hear the merits of this case and chucked it out at an early stage. So I think, unsurprisingly, that this will go back. This will now be remitted all the way back into the tribunal to come to a decision on the facts, and perhaps we'll see which way it falls, but perhaps may make its way up the court system again. But interesting nonetheless. That in this case, they seem more willing to go against the retailers or the sector. So perhaps one to contrast against the MinCap case in different sectors. That's of course not a very simplified view, it's not the only consideration, but yeah, interesting case nonetheless, and we'll see how that develops. So that was a very whistle-stop tour of a lot of cases, I realise. So thank you for your attention, and I'll now pass back over to Lorna to take you through for the rest. So thank you very much.
Thanks, Ben. I was just there in the middle of replying to a question which has come in the question section, but I didn't quite get to finish it, so I'll just answer the question verbally if that's okay. It was a question about rights to maternity leave and maternity pay for workers and employees. So just to clarify, the criteria to qualify for maternity leave and maternity pay are different. In order to qualify for maternity leave, somebody must be a worker. However, when it comes to qualifying for, let me rewind there. In order to qualify for maternity leave, somebody must be an employee and have employment status. However, when it comes to qualifying for maternity pay, the criteria are more surrounding the pay which has been received by the individual in the lead up to their maternity leave. So hopefully that clarifies that point, but I'll check again at the end for any further questions on that. Okay, so we're now going to move on to think about legislative and other developments. And as I indicated in the introduction, this section is perhaps shorter than what would be in normal times because most legislative proposals have been put on hold for the time being. So I'll spend a little bit of time thinking about these issues, and then we'll move on to spend some time thinking about some coronavirus related themes. Okay, so what has been happening? You may recall that back in 2016, the government did what was called a call for evidence on post-termination restrictions. Another word for post-termination restrictions is restrictive covenants. You might have come across those before. They commonly are inserted into contracts of employment for senior people within organisations, or perhaps those who do roles which involve communication with clients and customers. So a typical restrictive covenant would prevent somebody from working for a competitor after they've left for a certain period of time, usually within a certain geographical location. An alternative restrictive covenant, which is less onerous, prevents the former employee from soliciting customers or clients of the organisation. So clearly the purpose of the restrictive covenant is to limit what the former employee can do, usually in the months following on from their departure from the organisation. Back when the call for evidence was held in 2016, the conclusion of that was that no further regulation was required. The vast majority of organisations who responded felt that post-termination restrictions were an important tool in protecting the business interests of the organisation and didn't unduly restrict former employees from seeking alternative employment. But due to the economic impact of coronavirus, this issue has been revisited by the government. A consultation was launched back at the start of December and that closed at the end of February. The main proposals that were put forward during the consultation were either banning post-termination restrictions altogether, or instead imposing the requirement for the former employer to pay compensation for the duration of the restrictions, which is the model that applies in Italy, France and Germany. There were also some views sought on whether there should be further regulation in terms of transparency and communication surrounding post-termination restrictions, I suppose, so that people understand what they're signing up to, and also whether, in addition to compensation, the period of restrictions should be limited in some way. So we don't have any further developments to report following the conclusion of the consultation, but no doubt we will have some idea of how the government intends to proceed in the coming months. For those of you who work in the public sector, you will be familiar, I'm sure, with the cap on public sector exit payments, which was introduced in November last year. That was 5 years in the making and didn't even last 5 months on the statute books before it was repealed due to some fundamental problems. And the government has been quite widely criticised for pressing ahead with the introduction of the cap, despite many organisations and experts making it clear to the government that the scheme was unworkable. You may be familiar with the extension of the IR35 rules to medium and large private sector organisations. This was due to take effect in April last year. However, organisations were given a bit of a grace period due to the pressures of coronavirus, but this will now come into force on the 6th of April this year. This brings the private sector into line with the rules which currently apply in the public sector. And essentially, the purpose of the rules is to stop the practice of individuals providing services to organisations through an intermediary company, when in fact the reality is that the relationship is that of employer-employee. To structure the relationship with the use of an intermediary company obviously has tax implications for both the organisation and for the individual, and it very often occurs that an organisation will engage contractors who on a day-to-day basis do very similar jobs to employees who might in normal times be sitting beside one another in the workplace. So this is to try and ensure that individuals are treated consistently, and of course that all relevant tax are accounted for. The onus is on the organisation who engages the individual to determine the status of that person for tax purposes. So if the organisation gets it wrong, then liability for any unpaid tax lies with them. So organisations in the lead up to this have been going through the process of determining the status of contractors who work within the organisation in order to make sure that these rules are complied with from the 6th of April. Organisations also had a bit of a grace period in relation to gender pay gap reporting last year. The usual deadline for the submission of gender pay gap reports is April, and last year the deadline was removed altogether, so there was no requirement for organisations to report given the other pressures they were under. The government has said that this year the deadline will be extended from April to October. So organisations now have until the 5th of October to lodge their gender pay gap reports. Organisations are nonetheless encouraged to submit their gender pay gap reports in accordance with the usual timescales if they do have those available. Obviously, there are good reasons why organisations report on their gender pay gap, the primary one being to try and address equal pay issues. So those motivators haven't disappeared because of coronavirus. So if you are, as an organisation, in a position to issue your gender pay gap reporting statistics, then you should just go ahead and do that. There have been some issues and confusion surrounding the role that furlough plays in gender pay gap reporting, particularly when organisations have been paying people at the 80% rather than the 100%. In February, the Hampton Alexander Review published its 5th and final annual report on improving gender balance in FTSE leadership. And the report stated that as of the 11th of January this year, women held 36.2% of FTSE 100 board positions, and that was up from 32.4% in 2019. If you recall, there's a target of 33% in place. Out of the companies in the FTSE 100, 32 of them hadn't yet achieved that 33% target. So clearly we are making progress in this area, but still quite a lot of work to do. Okay, so these are the firm proposals which we have seen over the course of the last few months and which we expect to see going forward. But what I thought I would do next is just remind you of some of the things that were on the government's agenda back towards the end of 2019. You might recall that the government had proposed an employment bill. This is essentially the various employment related proposals that the Conservative government had when they won the election. And this is, of course, been put on hold for the time being. And hopefully, as we progress through 2021 and make good progress with the vaccination programme and other priorities can move further to the top of the agenda, this will be something that will be back on the table for discussion. So I'll just run through these relatively quickly. You may recall that following the publication of the Good Work Plan, the government proposed to introduce a single labour market enforcement agency. At the moment, there's 4 main bodies that enforce employment rights, and the purpose of this body would be twofold. First of all, to help particularly vulnerable workers understand and enforce their rights, and also to support employers in order to comply with employment laws. The government had proposed to introduce regulations to require organisations in the service industry to pass tips and service charges on to workers in full in a fair and transparent way, and that was to be supported with a statutory code of practice. One of the firmer proposals which came out of the Good Work Plan was a proposal to introduce a right to request a more predictable and stable contract after 26 weeks service. This was specifically geared towards those on 0 hours or flexible contracts. I suppose some of the proposals under the employment bill might have been superseded in some way as a result of the Uber case and the cases which will no doubt follow on from that, boosting the rights available to people who work in the gig economy. There was a proposal to extend redundancy protection in pregnancy and maternity situations, so that the period of protection would begin when the employee notifies the employer either verbally and in writing of the pregnancy through to 6 months after the end of the maternity leave period. And some of you, I'm sure, will know already that the protection which is currently available but for a shorter period of time means that women who are on maternity leave are entitled to first dibs on suitable alternative employment in a redundancy situation. So all that this proposal does is to extend the period during which that particular right applies. It doesn't increase the level of the protection as such. The government had proposed to introduce a right to leave and pay for neonatal care to allow parents of sick or premature babies to take some paid time off of work. The government proposed something which is very vague, and that is a week's pay, a week's leave for unpaid carers, but there were no further details in the Conservative Party's manifesto or which have come to light since, which tell us the details of what is proposed here. So is it a general entitlement, or is it only for emergency situations? Is it paid or is it unpaid? And what are the criteria? How do we define an unpaid carer? And finally, the government indicated its intention to make flexibility the default and to require employers to have good reason for declining flexibility in working hours. It's a little bit uncertain at the moment how this varies from the current right to flexible working. You'll be familiar with the fact at the moment employees subject to certain criteria can make a formal flexible working request, and that can only be rejected based on certain grounds. I think there are 8 grounds set out in the legislation. So I suppose we need to await the detail of what is proposed to see how the new regime will vary from the existing regime. And also no further news on the items on this slide. So if you recall, a couple of years ago, the government carried out quite an extensive consultation into the use of confidentiality clauses in contracts of employment and settlement agreements. And this had come into focus as a result of victims of sexual harassment being asked to sign non-disclosure agreements. The government had proposed putting certain limitations on the use of confidentiality clauses, and also introducing a requirement for people to take legal advice in a similar way as they do when signing a settlement agreement before entering into a non-disclosure agreement or other wise signing up to a confidentiality clause. So no further news on that at the moment. Addressing one-sided flexibility, so the proposal to address one-sided flexibility, you will probably recall, came out of the Good Work Plan, which was the extensive consultation carried out by Mr. Taylor. And out of all of the different proposals which were made and the ideas which were floated, the only one which made its way into the employment bill was the right to request a more stable and predictable contract, as I mentioned when we were looking at the last slide. So at the moment, no further details of the government's suggestions that they might introduce other ways to address one-sided flexibility, things like requiring organisations to provide employees or workers with a certain amount of notice of their shifts, and also to pay compensation in the event of shifts being cancelled at the last minute. So again, we need to just see in due course what the government proposes to do in order to address one-sided flexibility beyond just this right to request a more predictable and stable contract. You may also recall that the government produced a wide-ranging paper called Gender Equality at Every Stage, a Roadmap for Change. And some of the proposals made by the government are contained on the second part of this slide. So strengthening the equality legislation, closing the gender pay gap, reviewing the shared parental leave system, restructuring family leave and pay, and requiring employers to publish their family-friendly policies. So each of those on its own sounds like a massive exercise to me. So to include all of these within the one paper seems very ambitious. So again, we'll need to just wait and see what the government proposes to do there. Although our family-friendly system of leave and benefits is often criticised as being not particularly generous, it actually is one of the more generous systems in the EU, at least as far as leave is concerned. The pay lags behind some other European countries, of course. Okay, so if you have any questions about any of these developments or proposals, feel free to pop those in the chat section. I can see that some of you have done that already, and hopefully Ben is working his way through those. I think I got an easier ride than what he did. Okay, so moving on to coronavirus related themes next. Now it's inevitable that as more organisations anticipate a return to the workplace, people will start to raise concerns, and in particular they might be worried about whether they are safe in their workplace. And for those organisations who have already been working face-to-face again because the sector within which they operate is one which is currently permitted to operate, you will perhaps be familiar with some of these themes already. I'm sure that amongst the people that you know in your personal lives, your friendship groups and your families, you experience a range of different attitudes to coronavirus. Obviously, some people very cautious and very concerned about their safety, and other people perhaps quite blasé about it and not particularly compliant with the rules. So that experience will probably be reflective of your workplace as well, and the people who work within it. A range of different attitudes and concerns. So I think we always need to bear in mind that how we feel about the risk of coronavirus might not be the same as how other people feel, and other people's concerns, even if we don't think that there's any mileage in them, should still be taken seriously. Now there is a provision in the Employment Rights Act which relates to health and safety, which in normal times very rarely comes up, but it has been brought sharply into focus as a result of the current situation. And what that provision tells us is that in some circumstances, employees can either refuse to attend work or can leave work early on health and safety grounds. The employee needs to have a reasonable belief that either they or someone else is in serious or imminent danger, but crucially, the belief just needs to be reasonable. It doesn't need to be correct. And it's the employee's belief that is important, and it doesn't matter what the employer thinks, it's what the employee thinks which is important, and that can be quite difficult for organisations to get their head around, where they believe that they've put in place all of the appropriate mitigators. So let's think about what organisations can do in a practical sense in order to try and minimise the risk of this type of claim arising. Okay, so the number one step, and it is of absolute fundamental importance, is making sure that you have an up-to-date risk assessment in place. If you don't have an up-to-date risk assessment in place, then it means that you can't really go any further in terms of requiring a return to work. Of course, once you've done your up-to-date risk assessment, it's important to put in place all appropriate measures which have been identified by the risk assessment, paying particular attention to those in the groups that are most vulnerable to serious illness or death as a result of coronavirus. It's not enough to just put the measures in place, we also need to make sure that they are adequately communicated to employees, and that should provide employees with the assurance that you're doing everything that you need to in order to mitigate the risk. And of course, we're talking about things here like limiting the number of employees in the workplace, social distancing measures, signage, one-way systems, hand sanitising, all of the things that we're now very used to in our day-to-day lives. Not only will communicating the measures that you have taken to employees, hopefully provide them with some reassurance about returning to work. It will also help to defend the organisation against the type of claim that I was speaking about a few moments ago, because if you recall, the employee's belief has to be reasonable, but if you effectively communicate to employees the measures that you've put in place to mitigate the risk to them, perhaps we're able to convince an employment tribunal, if it becomes necessary, that the employee's view was not a reasonable one. If employees do raise any concerns about the measures that you propose to put in place or about their own individual circumstances, it's important to discuss those concerns sensitively. Answer any questions which are raised, and if you do at this stage need to put in place any further measures in order to mitigate the risk further and to provide reassurance to employees, then you should do that. Ultimately, if despite having done all of that, having taken all of these steps, the employee is still refusing to return to work, then at that stage it may be possible to start thinking about other options. For example, allowing them a period of unpaid leave, or perhaps treating their absence as unauthorised. But we do need to be very careful about taking those steps, because this is quite a risky area based on the legislative provision which I mentioned. And just to go back to that for a moment, if the employee is able to satisfy the employment tribunal that they do have a reasonable belief that somebody is in imminent and serious danger, and that has motivated either their refusal to return to work or their decision to leave work, then that means that they are protected. And if the employer subjects the employee to a detriment or dismisses them, then they will be able to raise a claim under this particular legislative provision. There has been one case so far that I've seen just at an employment tribunal level, which involved the refusal of an employee to attend work. And he actually had been attending work in a warehouse environment, but as a result of his perceived risk, he left work and didn't return, and ultimately he was dismissed by his employer. He failed in his claim under this legislative provision because the employment tribunal was convinced that the employer had put in place all of the necessary mitigators, had communicated those steps to the employee, and therefore the employee's belief about the risk that he was in was unreasonable. The working environment was a large warehouse where social distancing was very easy. And the odd occasion where people couldn't socially distance, I think there was an example given where two people had to work together to carry an item, and there were other mitigators in place, masks, for example. So if you do have any situations which fall into the type of scenario that I've just described there, do make sure that you take advice before you take any further action. Hopefully most concerns can be overcome just through good communication between the employee and the line manager. But ultimately, if it does get to the point where the employee is persistently refusing to return to work, then we need to think about further steps. Okay, so another question which has come up recently is whether an organisation can require its employees to be vaccinated. And of course, you certainly can't hold down an employee and stick a vaccination in their arm, as that would amount to assault. So the discussion is more focused on whether you can ultimately take disciplinary action and possibly dismiss an employee who refuses to be vaccinated. So let's just spend a little bit of time thinking through the legal factors which should be considered. So first of all, for new starts, it's likely that vaccination can be made a condition of employment, although it is important to bear in mind that you may need to make exceptions for certain individuals in order to avoid the risk of a discrimination claim. for example, those who are pregnant or perhaps have certain disabilities and therefore for whom vaccination isn't advised. You might have seen in the media that the owner of Pimlico Plumbers, an organisation who have found themselves in the media in the past due to employment issues, has said that for new starts, I think they do, well, as the name suggests, plumbing and other similar trades, vaccination will be a requirement, presumably because they're going in and out of people's homes, and the organisation wants to protect the plumbers themselves and also provide comfort to customers whose homes that they're entering. So that is the position for new starts. Some organisations like Pimlico Plumbers will now choose to build in a requirement to be vaccinated into the offer letter in the contract of employment. But as you would expect, the position is much more complicated for existing employees, because it is extremely unlikely that there will be any contractual provisions in existing contracts which compel employees to be vaccinated in the event of a pandemic. Of course, it's just something that we have never anticipated in the past. So for existing employees, whether the employer can require vaccination will very much depend on the particular circumstances, including the nature of the workplace and the employee's role. So you might have seen some large care organisations come out and say that they require, in the main, their health and social care staff to be vaccinated, and the argument which is put forward is to prevent or mitigate the risk of catching coronavirus, both from the point of view of their employees and also the individuals who they provide services to. Now, in that type of sector, it's much more likely that mandatory vaccination will be justified. I would say it's going to be quite difficult for most other types of organisation to justify a policy of mandatory vaccination. The Employment Tribunal, I think, although of course this is an untested area, would consider the nature of the workplace, the role that the employee does within the organisation, and any other relevant factors as well. For example, does the employee have to travel as part of their role, and do the countries that they have to travel to require people entering to have a vaccination passport, I think is the term that's been used, in order to gain access. It might also be relevant to think about the impact of self-isolation on the workplace. So the care sector has been particularly hard hit by this. If one employee tests positive, that might then result in the need for many others to self-isolate, which can impact their ability to provide a service. With a mandatory vaccination policy, there will be an element of weighing up required, and that will be done through a risk assessment. And as part of that risk assessment, the employer will need to consider what the advantages are of vaccination. And at the moment, that's a little bit uncertain, because if we take the example of the care sector and the motivation to protect or mitigate the risk to service users, at the moment, there's not any firm evidence that the vaccination prevents the virus from being transmitted. So if that is the case, then clearly the potential motivator of protecting or mitigating the risk to service users is potentially undermined. There does seem to be emerging data, though, that the vaccine is at least partly effective in avoiding transmission. So as data becomes clearer on that, the balance will no doubt shift. So if the risk assessment does identify vaccination as an appropriate measure, then requiring employees to be vaccinated may amount to a reasonable management instruction. And as some of you may be aware, the unreasonable refusal to comply with a reasonable management instruction can be grounds for termination of employment for gross misconduct. So let's just come back to that in a moment, because first of all, I think it's important to consider on a practical level what to do if an employee objects to being vaccinated, because of course we want to take time to understand their concerns. We don't immediately jump in with the threat of potential dismissal. So if an employee does object, we would clearly want to explain what our motivator is for requiring employees to be vaccinated with reference to our risk assessment. We will want to take a bit of time to explore the concerns that they have and to try and alleviate those concerns. Now, of course, if their concerns are connected to protected characteristics, then we will need to be mindful of the discrimination risk, and we'll come back to think about that in a bit more detail in a moment. But ultimately, if all else fails, then the employer may need to suggest to the employee that perhaps they do alternative duties for a period. Maybe if they do work in a care organisation, for example, instead of doing day-to-day caring responsibilities, they perhaps do a role which involves less contact with service users. The extent to which that's realistic or sensible, I'm not sure. That would come down to the process of weighing up the different factors that the organisation would undertake, and disciplinary action may ultimately be considered as well, and we'll now move on to think about that in a little bit more detail. So the ultimate question, can you dismiss an employee who refuses to be vaccinated contrary to your vaccination policy? Well, unfortunately, there's no one-size-fits-all answer to that question, because it takes us back to what we were considering a moment ago, whether, first of all, the requirement to be vaccinated is a reasonable management instruction, thinking about some of the factors that we've discussed already, and also whether the employee's decision to refuse to be vaccinated is an unreasonable one, because whilst it might be reasonable for the employer to have a general policy of requiring vaccination, it will also be important to consider the individual's motivation for refusing to have the vaccination, and that brings into consideration some of the potential discrimination risks. So the most obvious ones will be pregnancy and disability and religious and philosophical beliefs. So we'll just think about those in a little bit more detail. So back at the beginning of the vaccination programme, I believe that women who are pregnant were advised not to have the vaccination, and now the advice has changed a little bit, so that if the woman is subject to or exposed to the risk of coronavirus, perhaps because of the environment within which they work, it may be advisable for them to get the vaccination. So I suppose it's about weighing up the risk of getting coronavirus with the risks associated with the vaccination. For those who have disabilities, it might be that the nature of their disability means that it's not recommended for them to have the vaccination. Some people are concerned about the vaccination because of a potential allergic reaction, maybe because they have a history of extreme allergic reactions in the past. Whilst an allergic reaction on its own probably isn't enough to amount to a disability under the Equality Act, nonetheless, it's obviously a very reasonable excuse for the employee to put forward for not wanting to have the vaccination. So although there might not be a discrimination risk there, we still need to factor that into our decision-making process. Some people who hold certain religious beliefs might be opposed to vaccination on the basis that the vaccine contains animal products. And again, that's something that we would need to take into account in terms of our considerations. Information related to health and vaccination is likely to amount to special category data under the Data Protection Act and GDPR, which brings with it certain serious considerations. So employers will need to think about the data that they gather in terms of health and vaccination, and what they do with that information and how that information is stored, for example. I'll not go into any more detail about that at the moment. There's some really, really useful information on the ICO website, which takes employers through all of the relevant considerations regarding how the data protection rules sit with both vaccination and testing. So I would encourage you to make reference to that. Just one other point worth bearing in mind when it comes to unfair dismissal. So I've talked already about the potential to dismiss an employee for misconduct, for unreasonably refusing to follow a reasonable management instruction, bit of a mouthful. If an employee is dismissed for that reason, then generally they're not entitled to any notice or pay in lieu of notice. So it is a very harsh outcome. And for that reason, employers might want to instead thinking about dismissing for some other substantial reason. You might have heard that term before. It's one of the 5 potentially fair reasons for dismissal under the Employment Rights Act. The process that you would follow is much the same, but the dismissal or the termination of employment would be with notice or pay in lieu of notice for the employee. So the outcome isn't quite as harsh in that they don't lose their right to notice, and also the reason for the dismissal is less focused on blameworthy conduct and more just on the situation within which the parties have found themselves. Okay, so we've thought over the course of the last 5 minutes or so about whether employers can introduce a mandatory vaccination requirement. And now we're going to think about something similar, which is whether employers can introduce a mandatory testing policy. Now, the government has said that whether testing policies are voluntary or mandatory is at the discretion of the individual employer. However, I think when they make that statement, they do so in a general way rather than having done an analysis of the different employment law risks. So it will be for each organisation to consider whether any testing policy which they introduce will be voluntary or mandatory, taking into account some of the circumstances that we spoke about in relation to vaccination. So in many workplaces, it will not be possible to introduce a mandatory testing programme because other mitigators are perfectly adequate. For example, minimising the number of people in the workplace, having screens in place if people are not able to socially distance, and some of the other mitigators that we've spoken about. So if you can mitigate the risk in another way, it makes it difficult to justify mandatory testing. But like we talked about in relation to vaccination, there might be some other circumstances, like the care sector, where mandatory testing could potentially be justified. However, before the organisation implements that type of policy, they would need to consult with employees and trade unions in order to seek and hopefully achieve an agreement to incorporate the need to be tested into the individual contracts of employment of the employees. That might be done through a collective agreement with the trade union. And like with vaccination, it would be more straightforward to introduce this type of requirement into new contracts of employment than it is into existing contracts of employment. I suspect most organisations who do want to offer testing will do so in a voluntary way, although there are still certain considerations that will need to be factored in there. No doubt employees will want to know what will happen in the event that they do test positive and they don't otherwise have symptoms. For example, will they be paid for the self-isolation period, and will that absence count towards any absence management triggers that the organisation has in place? It's understandable that if the employer doesn't address those concerns in an effective way, people will simply opt out of voluntary testing. So lots of different considerations there. I believe that in England, organisations have until round about the middle of April, might be the 12th of April, but don't quote me on that, to register to receive free lateral flow tests from the government. So if this is something that you're thinking about, then you might want to try and focus your mind before the 12th of April so that you can take advantage of that. Okay, so now moving on to consideration which is high on the agenda of many organisations at the moment. So as lockdown restrictions ease and a return to normal working is in sight, what does your organisation plan to do in terms of home working versus office-based working, which I'm assuming is the environment most of you are in? So first of all, we'll consider some of the relevant contractual issues, and then we'll think about some of the practical issues that you will no doubt want to factor into your decision making. Lots of large, high-profile organisations have come out and said that they don't anticipate a full-time return to the workplace for the vast majority of employees. And so what we need to think about is what are the contractual considerations that we should factor into our decision making, because lots of organisations, I think, simply assume that if they want to introduce hybrid working, then they can do so. However, there are certain contractual considerations that are required, and that's because it's unlikely that the place of work clause within your employees' contracts of employment will be defined in such a way to allow employers to force home working on employees. And ultimately what that means is that if the employer does force hybrid working on employees, that might amount to a breach of contract. Most place of work clauses in contracts of employment do provide for a limited degree of flexibility. However, important to note that flexibility clauses are limited in terms of their use because they are generally interpreted very narrowly by the employment tribunal. So typically a flexibility clause in the place of work section of the employment contract might say something like, your normal place of work is the Glasgow branch, but you may be required to work from any of our other branches, either on a permanent or temporary basis. Well, that type of clause is not going to cover the scenario where somebody is required to work from home for some or all of the working week. So if we just work on the basis that there is no scope within the contract to impose hybrid working, then the safest approach would be to seek agreement to amend the contract of employment, and depending on whether the organisation recognises a trade union, that would either be done through seeking individual agreement to amend or alternatively using a collective agreement. And if there are more than 20 people who are affected by the change, then the collective consultation rules would apply, and those bring with them a minimum consultation period of either 30 or 45 days, depending on the number of affected employees. So strictly speaking, that is the process that an organisation should go through if they don't have scope within the employees' current contracts of employment to impose home or hybrid working. Now, although that is strictly speaking what is required, lots of organisations will no doubt take what you could describe as a more commercial approach. So they might decide that actually the risk of people objecting to home working is so low that they will simply impose the change, and if there are any concerns raised, they will deal with those on an individual basis. So for example, if you decide to impose hybrid working on 100 employees, then you might get 5 employees who come back and say, this doesn't work for me, perhaps because they have other people in their household who disrupt them, or because they don't have a suitable work area within their home. And you might be able to then make exceptions for those people, and that might avoid the need for the amendments to the contract of employment that we've talked about already. So there's a range of factors to consider. They are balancing up the risk and the need for a commercial approach in some circumstances. Okay, so in addition to the contractual issues, there are some other issues that you might want to consider. So I suspect that most employers will want to retain some flexibility to bring people into the workplace where physical attendance would be preferable, for example, training, brainstorming exercises, and formal meetings. So if you are amending contracts of employment, make sure that you do build in that flexibility. Think about how communication will be managed when some people are in the workplace and other people are at home. Obviously, at the moment, most people are working from home and therefore are on equal footing. So if everybody's dialing into a meeting, everybody is in the same position. But if we have some people who are present in the workplace participating in the meeting and other people dialing in from home, then arguably we're not on a level playing field, and it might be more difficult to foster good communication. Just before coronavirus hit, I was doing a training session for one of our clients at their offices, And due to travel disruption, some people weren't able to attend, so they dialed in using Microsoft Teams. That was my first experience of Microsoft Teams, and as it turns out, it was a good little introduction before it became much more widespread in its use. But I did have to continuously remind myself of the fact that there were some people who had dialed in rather than who were present at the meeting, because it is easier to forget about people when they're dialed in rather than present in the same room. So that is something organisations are going to have to think about and manage. Obviously, hybrid working involves making sure that health and safety standards are met both at home and in the workplace. Back when we were thrust into the world of home working at very short notice, understandably, employers were not able to do all of the usual home working health and safety checks that they would typically do. But obviously, when this becomes planned as opposed to emergency, then the expectations on organisations are increased. Carry out an equality impact assessment to identify any particular disadvantages which may be experienced by certain groups. Ben talked about cases involving indirect discrimination, where you apply a policy, criteria or practice across the board to everybody, but it has a disproportionate impact on a particular group. That's certainly a risk of introducing hybrid working, and an equality impact assessment will just help you to identify whether that risk does exist, and if so, it will encourage you to think about what steps you can take to mitigate the risk. There might be alternatives, for example. Make inclusion a priority. I'm not going to get into all of the details because unconscious bias is a huge and very interesting topic in itself. I'll just highlight one interesting facet of unconscious bias, which I'm sure many of you will recognise, and that is in-group or affinity bias, where we are naturally drawn to people who are similar to us in terms of our gender, age, race, religion, socio-economic status, etc. And workplaces are one of the few occasions in which we are forced to interact with people who are not like us, and they therefore present a really positive opportunity for people to expand their horizons and to engage with and socialise with people who they might not otherwise come into contact with in their day-to-day lives. And there's a risk that hybrid working will compromise that, so important to think about the different aspects of that as part of your considerations. There's also going to be a need to make sure that everybody is suitably trained. Managers should be trained on how to effectively manage employees who are working from home, at least for part of the week, and employees should receive training as well on things like data protection. Obviously, as people start to move between the workplace and their home, potentially taking with them information which contains personal data, we need to be very careful that people understand what the rules are. Okay, so just before we move on to our final section, which should only take around about 10 minutes, I wanted to share another couple of polls with you, just so that we can gauge what your organisation's plans are. Now, it might be that some of your organisations haven't got to this point yet, but I'm just going to give you the opportunity to share with the rest of the group whether you do have any plans related to the topics that we've discussed. So the first poll I'm going to share with you asks, does your organisation plan to introduce mandatory vaccination? So I'm launching that poll now, hopefully. Okay, I'm going to close that now. Oh, I think I've possibly missed the opportunity to show you the poll results, so let me just talk you through those. Oh, maybe you can see them now. Sorry, this is the first time I've used this new system, so I'm not exactly sure what you're seeing at the moment, but I'll talk you through it anyway, just in case. So only a very small proportion of organisations within the session saying yes, they do plan to introduce mandatory vaccination. Perhaps those are the organisations which have identified a particular need to, based on the purpose of the organisation and the roles that employees do, like the care sector, for example. 64%, so the majority of people saying no, that's not a plan their organisation has. And then quite a large number, 32% of organisations are unsure on what they plan to do at the moment, and that's understandable. It is a issue which does require some consideration. Hopefully you're in a better position to think through the relevant factors after today's session. Okay. Right, so our next poll asks you, does your organisation plan to introduce mandatory testing? And of course, lots of organisations, for example, in the health sector and education, have introduced testing already, because they are currently back at work, but I understand that's done largely on a voluntary basis. Okay. Okay, I'm going to close this now. Okay, so 12% of organisations said yes, and so that would then seem that more organisations plan to introduce mandatory testing than plan to introduce mandatory vaccination. 57% of people saying no, that's not something their organisation plans to do, and again a reasonable proportion, 31%, unsure at the moment. Okay, so that was mandatory testing, and so the next one I'll share asks you whether your organisation plans to introduce voluntary testing. Okay, let's just close that now. So I can see somebody's asking, can we see the poll results? So I'm assuming that means that they're not coming up on your screen. So sorry about that. I've obviously done something wrong there. So let me just verbally describe the results. So 27% of organisations saying yes, they do plan to introduce voluntary testing, 33% saying no, and 40% unsure. So again, quite a large proportion of organisations having not quite reached a final decision on that yet. And then our last poll is your organisation planning for hybrid working? Okay, I'm going to close that now. So a large 63% of you saying that your organisation is planning hybrid working. Now, of course, hybrid working can mean different things to different organisations, particularly when it comes to the proportion of time spent in the workplace versus the proportion of time spent at home. 20% saying no and 16% saying unsure. So this is certainly, out of all of the different questions I've asked you, in the area where there seems to have been more thought given to the future planning. And so hopefully you'll take away then from today's session just some further issues to consider before you reach a final decision on that. as with all of these things, communication is obviously going to be really important, how you engage with employees to get them on board. Okay, so let's just move on to our final section, and hopefully we'll still have 5 minutes or so for questions at the end. Hopefully Ben's answered some of those in the questions section as we've gone through as well. Okay, so now that we are no longer bound by the decisions of the European Court of Justice, and we no longer need to implement directives which the EU introduce, we have, of course, much more autonomy to decide what our employment laws should be. It was interesting, I don't know if anybody followed this, that the business secretary initially said that there would be no dilution of workers' rights post-Brexit. But then on reflection, he altered his commitment and said that EU-derived rights were under review, but they wouldn't be disposed of in a bonfire-like fashion. So those are two quite different statements. So I think we can expect to see some changes, not a whole-scale rewriting of our employment laws, but instead perhaps just some tweaks around the edges, perhaps focusing on the areas which the government has previously indicated that they consider to be problematic and which have presented challenges for business. So we might see some changes to the working time regulations, which of course were introduced in order to comply with the EU's working time directive. For example, we might see the 48-hour limit on a working week being removed, although that wouldn't have much practical implications given that there's already an opt-out in place for that anyway. At the moment, the working time regulations have to be interpreted in accordance with decisions of the European Court of Justice, and the European Court of Justice has decided that for peripatetic workers, in other words, those who travel to different locations throughout the course of their working day, working time starts when they leave their home in the morning, and that is at odds with other employment law rules that we have in the UK. So we might see that changed. And the big one is holiday pay calculation. So I'm sure you'll all know that for the last 5 years or so, we've been grappling with the developing case law in this area, particularly focused on what types of additional payments, for example, overtime or commission, should be included in the calculation of holiday pay. And that's resulted in quite a large burden on organisations. So the government may decide to legislate to reverse some of the decisions which were taken by the European Court of Justice in that area. It's been speculated that we might see a cap on discrimination compensation in a similar way as we have a cap to unfair dismissal compensation. That would potentially prevent awards of compensation getting into six-figure sums, which we do occasionally see. To pay is an area which is derived from the EU, where some of the rules have been criticised in the past as being unduly cumbersome for businesses. So it might be that we see some changes to the consultation rules, perhaps the introduction of a minimum number of affected employees before the consultation rules kick in a similar way to redundancy collective consultation. We might see a relaxation of the rules regarding the harmonisation of terms and conditions when essentially two organisations or more than two organisations become one. The agency worker regulations have generally been pretty unpopular, and so we might see the abolition of those. They're not regulations which come up particularly often, so the practical implications there will perhaps not be significant across the board, although maybe have quite a large impact for certain specific organisations or sectors who use agency workers heavily. And really just to finish off with a brief reminder of the government's new immigration system, which came into effect at the start of this year. So as we left the EU, then free movement within the EU ended on the 31st of December. And from the 1st of January this year, a new points-based immigration system applies to both EU and non-EU migrants, meaning that they're required to obtain a visa before entry to the UK. Most people will use the skilled worker route. That was previously known as Category 2, or Category 2 was probably the most similar route to the skilled worker route in old terminology. And that requires a job offer from a licensed sponsor, and that has to be at a required skill level with payment at the relevant salary threshold. Although without getting into too many details, because it is quite complicated, that can be traded for points elsewhere. There's also a requirement to speak English. There are some concessions to those criteria for shortage occupations. EU and EEA citizens who were resident in the UK on or before the 31st of December don't need to apply for a visa using the new points-based system. Instead, they can apply for settled status through the EU settlement scheme. The settlement scheme closes on the 30th of June this year. So whilst it is good practice to, in general, communicate with your employees about the settlement scheme and make sure that they understand the deadline and what the requirements of applying under the scheme are, you can't ask employees to provide evidence of settled status before the 30th of June. That brings with it certain race discrimination risks. Okay, so that brings us to the end of the session. Oh, I forgot that I had a little plug here in at the end. You will have caught earlier on during the introduction, I am a WhatWorks Employment Law and HR Training Manager, so I am the best person to contact if you do have any questions about the type of training that we can offer to support your business. At the moment, obviously, face-to-face training is heavily restricted, and so over the course of the last year, all of the training that I have been delivering has been using your usual online platforms. It's been done very successfully, even if I do say so myself. All of the materials have been adapted in order to continue making them engaging and interactive, so using some of the different functionality that is available on those systems. And we also work with an e-learning provider to provide our clients with the option of e-learning modules, and our clients benefit from a discounted rate. So I'll not go into any more detail of that, but if you do want any more information, then you're welcome to contact me and we can arrange a catch up, or I can just send you some literature. Okay, sorry, I'm rushing here because I want to just have a few minutes to take some questions, and so let me just briefly scan through the questions that have been asked and which haven't been answered by Ben yet. Okay, so one organisation asking, is it acceptable to request everyone returns to work following the easing of the restrictions? As a small team, it's more efficient when everyone is in the office and has access to all the necessary equipment. Yeah, absolutely. Presumably that would be in accordance with your contracts of employment that existing employees already have. There will be many organisations who have seen benefits from home working and who want to continue to harness those benefits and want to offer flexibility to employees. And if your business fits into that category, then that's brilliant. But equally, there will be some organisations who feel that working from the workplace is just simply more effective, in which case, once the restrictions allow, it will be possible to require those people to come back into the workplace. Obviously, just bearing in mind the risks that I spoke about earlier on of people arguing that they don't feel safe coming back into the workplace. Would it be necessary to carry out an equality impact assessment if we plan to use flexible working for working requests for hybrid working? In other words, we will not be forcing hybrid working. Okay, so I think what we're being asked there is if the default is a return to work or return to workplace, but individuals want to specifically request different arrangements, as an equality impact assessment required? No, I don't think so, because as part of the process of considering the flexible working request from an individual, you will take into account all of the relevant factors. Just one more. Sorry, some of these questions are quite lengthy. If an employee has made it known to colleagues that they've refused to have the vaccination for any reason, and a colleague refuses to work with the individual or be in their presence, and it's a small office area, where does the employer stand if they have no capacity to change office layouts, etc.? That's a really interesting question. So I think that we will probably just need to understand a little bit more about the data related to the impact that vaccination has on transmission before we can be any clearer on that. If the vaccination is effective in limiting transmission, then that may become a non-issue. If vaccination is not effective, then, or effective enough to prevent transmission, then I think we would need to think about other possible mitigators. So, for example, if it's not possible to have people socially distance from one another, can we perhaps put screens in place between workstations? Obviously, we need to be mindful here of the risk of harassment and bullying as well, because we can't have employees being kind of victimised or singled out by their colleagues for refusing vaccination. Okay, apologies, I'm not able to answer any more of the questions. There are quite a large number and range of questions that have come in there, but hopefully you will still have gained some useful information from the session today. Obviously, if you are one of our clients, then you can ask these questions to your employment solicitor or your HR consultant. Great, well, that just leaves me with the need to thank you for coming along to our session today. I hope you found it useful, and hope to see you again at another session soon.